Katz v. United States was decided in 1967, and this important Fourth Amendment case establishes what's known as the reasonable expectation of privacy test. This analysis replaced an older line of cases that looked at whether or not the place itself was constitutionally protected and whether or not the government had physically intruded or trespassed upon this place. Charles Katz was a college basketball handicapper who lived in California, and he would go to these telephone booths outside of his apartment and call his associates back in Miami and Boston to relay the betting information. The federal authorities caught wind of this, and they put listening devices outside of the telephone booth because they thought they could do this without a warrant because they weren't physically trespassing on the constitutionally protected space of the inside of the telephone booth. But if they put the device outside, they would be on the right side of the Constitution. They used his conversations to convict him, and he appealed to the U.S. Supreme Court, and the U.S. Supreme Court overturned his conviction and said that they needed to not focus so much on the space itself because the Fourth Amendment protects people, not places. And so they established what's known as the reasonable expectation of privacy. Does a person have a reasonable expectation of privacy where they're at, and are they exhibiting it from a subjective point of view? This replaces the idea that the court needed to look at the actual space that they were in and instead look at the person, look at the facts surrounding them and ask, does that person have a reasonable expectation of privacy that society is willing to protect? And if so, before you make a search or seizure, you need a warrant on probable cause.